Well, good morning, everyone, and welcome to our Immigration Update webinar. We are so glad that you have joined us today. My name is Rachel Dupin, and I'm the Chamber Manager for the U.S.-India Chamber of Commerce, DFW. Let me tell you a little bit about our chamber before we get started. The U.S.-India Chamber of Commerce, DFW, is a Dallas-Fort Worth-based 501c6 organization whose mission is to support professional, business, and economic development throughout North Texas and to facilitate bilateral trade with India. The Chamber's services include business consulting, networking and knowledge events, conferences, trade missions, and partnerships with academic institutions. You can learn more at our website, www.usicoc.org. That's usicoc.org. And join us again next week. We have another informative webinar coming up. Our webinar on Friday, August 21st, will be at 10 a.m. and we are partnering with My Tax Filer for a discussion on tax planning and lending for small business owners. You can find out more and get the registration link in our chamber newsletter or on our social media at USICOC-DFW. And if you're not getting our newsletters right now, you can sign up to receive them on our website, www.usicoc.org. Now, before we begin, I want to let you know that the information in this webinar is not legal advice. This webinar is for informational purposes only. Please consult with your attorney to discuss your own individual needs and circumstances. And if you'd like to be connected with Chris Prescott, email the chamber at info@usicoc.org, and I will be happy to connect you. That email again is info, that's info, @usicoc.org. And now it's my pleasure to introduce to you today our speaker. Chris Prescott is a partner at Patel Law Group in Irving, Texas. Patel Law Group is a full-service law firm based out of Irving, Texas, and they also have offices in Houston and in Oklahoma. Chris specializes in immigration law and handles all employment and family-based immigration matters, including H-1Bs, L-1s, PERMs, I-140s, marriage-based petitions, and applications for naturalizations. Chris represents a variety of corporate clients in the Dallas area and throughout the U.S. in all aspects of immigration law, and prides himself on providing fast and effective legal advice to help businesses achieve their goals. In particular, Chris works with numerous IT consulting firms and advises them on the frequent changes in the law to help his clients navigate the ever-changing landscape. Welcome, Chris.
Thank you, Rachel. Good morning.
Good morning to you as well. We're going to start and just get right into it. So can you tell us about the two presidential proclamations and whether those are still in effect?
Absolutely. So the first presidential proclamation was issued on April 22nd. That effectively suspended the entry of immigrants. So when we talk about immigrants, we're talking about somebody that's applying for a green card, and that applied to people outside of the US that didn't have a valid visa or travel documents. The proclamation was in effect for a period of 60 days. There are a number of exceptions that were listed in the proclamation to include spouses and children of US citizens, EB1 investors, anyone whose entry would be considered to be in the national interest. So when that proclamation was put into effect, the consulates were closed anyway, so it was almost impossible for anyone to obtain a visa. However, on June 22nd, the president then issued a second proclamation, effectively extending the first one. So what that means is that through December 31st of this year, anyone outside of the US seeking to apply for an immigrant visa is unable to do so unless they can fall into one of the exceptions. The difference with the second proclamation is it also included a number of non-immigrant visa categories. So it applies to anyone that's on a H-1B, H-2B, a H-4, or anyone on a J or an L visa. Again, it only applies to people outside of the US without a valid visa or travel documents. So for example, if somebody is within the US and they're applying for a green card, if they're applying for a H-1B transfer or extension, they can still do that, so they're not affected by the proclamation. This week, the Department of State actually issued some additional guidance, some guidance as to whether, when somebody can apply for a national interest exemption, but there was also an additional exemption for people on H1B. So what's happened is when the second proclamation was issued, there were certain people that were outside of the US that didn't have a valid visa and were then prevented from getting a visa because of the proclamation. Well, the new exemptions provided by the Department of State apply to certain people on H1B, but they're really more guided at more senior workers, people that have kind of very unique experience, people that are being paid 15% more than the prevailing wage. So there are some additional exemptions. However, there's still a lot of people impacted by these proclamations, but there have been a number of lawsuits that have been filed. And one of the lawsuits I wanted to talk about today was one that was filed by the American Immigration Lawyers Association. So this was filed back in April. It was amended in, I think, July. So it now covers kind of the whole spectrum of plaintiffs. So there's people that are employers of H1B, L1, J1 sponsors, a lot of family-based applicants. And there's actually a hearing now on August 27th where the American Immigration Lawyers Association is seeking an injunction. So what that means is that the judge will make a decision whether to issue a nationwide injunction. If there is a nationwide injunction, it means that the Trump administration will not be able to enforce those proclamations. If for some reason the judge decides to side with the Trump administration, it means that those proclamations will stay in place. So right now they are in place, but I think in 2 weeks we're going to have, a little bit more clarity on that.
Do you have any sense of which way the judge is going to rule?
When somebody asked me about this, I think it was a month ago at another webinar, I was very kind of skeptical because the president does have the power to restrict aliens or classes of aliens into the US, but he does have to show that it's detrimental to the US. And in doing so, that means he needs to undertake detailed analysis. They have to provide like hard economic data to show that allowing people into the US will actually affect American jobs. In other words, they have to look at the sectors where there's high unemployment and actually say, look, when Americans are looking for jobs, they're going to have to directly compete with foreign nationals. Well, the majority of foreign nationals, particularly people on H1B, for example, they work in the IT industry. The IT industry doesn't have a particularly high unemployment rate. Obviously, with COVID, we've seen people lose jobs in like retail, bars, restaurants. These are not the types of jobs that US workers are going to be competing with foreign nationals. So there isn't really any evidence, and all of the evidence seems to suggest that immigration helps grow the economy and actually improves the working conditions of US workers. So having read the lawsuit, I'm a lot more optimistic, and I do think that it stands a very good chance. The only thing I would say is even if we get a nationwide injunction, there isn't anything to stop the president from potentially issuing another proclamation where they do their research, they narrow down the they increase the number of exceptions. So it's always possible that we could see something further. But I do think, based on my reading of the lawsuit, that it's likely that we will get a motion granted for the injunction.
Okay, thank you. Can you tell us about the announcements that were made last month regarding F1 and M1 students?
Absolutely. So just to give you a little bit of a background, in March, President Trump had declared a national emergency because of COVID. And then the Student and Exchange Visitor Program, which is what governs international students, had basically provided some guidance allowing international students to take courses online and still maintain their F1 status. Well, the original regulation says that international students can only take one online course per semester. So we had this guidance essentially saying that students could study online, and the intention, or people believed that that would follow through to the fall semester. Well, on July 6th, the SEVP made an announcement saying that any student or any international student, which covers F1 and M1 students, anyone that would be attending a fully online course in the fall semester would either have to leave the US or they would have to transfer to a school offering some sort of face-to-face instruction. So this announcement kind of came out of nowhere. Schools and students were scrambling to try and figure out what to do for the fall semester. Some potential students were having to consider abandoning their studies to go back home because a lot of the universities were only offering online instruction. This was another lawsuit. The announcement was made on the Monday, and I think it was on the Wednesday when both Harvard and MIT filed a federal lawsuit, again requesting an injunction. On the day of the hearing, the government actually backed down, and because they obviously realized that the rule was indefensible, and they said that students would be allowed to continue studying online. However, new students that were coming to the US, if the course was purely online, they wouldn't be allowed to come to the US. And I think the rationale there was, well, if you've never been to the US, you've never studied, and the course is going to be online, then you could just as easily study from abroad. So that's kind of where we're at now. Students that are in the US can continue to study online. New students, the only way that they can come to the US is if it's more of a hybrid course where it's a mixture of online instruction and then also face-to-face instruction. So that was a big development, but luckily it kind of, things resolved themselves.
Okay. Well, let's talk now about the public charge rule. Can you provide us with an update on the public charge rule that was introduced in February of this year?
Absolutely. So the new public charge rule was another initiative under the Trump administration. It was another rule that there'd been a number of federal lawsuits. The Supreme Court actually ruled in favor of the Trump administration, which allowed the Trump administration to implement this new rule. The new public charge rule essentially requires an officer to make a determination as to whether somebody is likely to become a public charge. What that means is somebody likely to receive 12 months of public benefits within a 36-month period? So what you are having is, and this applies really more to immigrants, as somebody that's applying for a green card within the US or applying from outside the US, but it was requiring the officer to make a future determination and say, look, I think this person is likely to receive 12 months of public benefits, without having really any regard to whether the person was even eligible for those benefits. So I think the biggest criticism of this rule is that it was creating a wealth test. It was kind of aimed at more low-income families. And again, this is another case where we saw a federal lawsuit, and I think it was last week, it was a district court in the Southern District of New York had basically ruled and provided a nationwide injunction, which means that if anyone that is an intending immigrant and they receive a public benefit during the COVID-19 national emergency, the Trump administration would not be able to implement that rule against them. So I think the fear with this rule, particularly during COVID, is that there were certain people that were not seeking testing or treatment for COVID because they didn't want to get labeled a public charge. So the judge said, look, this isn't fair. We obviously need to stop the spread of COVID. So the idea of implementing the injunction is that means that people that need to go for testing or treatment and it's government assisted, they can still do that and it won't affect their green card application. So again, sorry, go on.
I was going to ask, is the Trump administration appealing that ruling?
Right now they've agreed, USCIS has taken the form off their website. The Department of State has agreed to abide by it. I think it's something that may get back to the Supreme Court, But the one thing to bear in mind, it's only a temporary injunction. It's only whilst there is a national emergency. So once we get through COVID-19, if Trump declares that there's no longer a national emergency, then we may see that rule go back into place. But obviously, we're only 3 months away from the election. So if Trump doesn't get re-elected, this is one of those types of rules that I would expect to see withdrawn.
Okay. Well, let's move on. We're going to talk about the increase in fees that we heard about recently. Can you tell us about that recent announcement by USCIS to increase its fees?
Yeah, so this is something they've been talking about for a while. So just to kind of provide some background, so USCIS, which falls under the Department of Homeland Security, they're the agency that obviously handle all the immigration petitions. They're entirely funded by fees. There's been a lot of articles in the news where USCIS is saying that they're strapped for cash, they're seeking a bailout from Congress in the point to the tune of 1.2 billion. And there was an article in USA Today earlier this week, and it looks like that Congress isn't going to fund them. So USCIS has now announced that they may have to furlough. Well, they'd already announced it, but it seems like it's more of a definite thing that they are going to furlough essentially 2/3 of their staff because they don't have sufficient funding. So if that happens, it's going to happen at the end of the month, which is going to increase the processing times. But going back to the fees, one of the ways that USCIS is trying to increase the number of fees is to essentially introduce a new fee structure. So what that means is that all of the fees across the board have essentially increased. So some of the fees have increased by as much as 300%. If somebody's applying, for example, for naturalization, the fee has increased by 83%. It's gone from, I think it's $640 to $1,125. Anyone that is within the US that's applying for a green card, for example, if they're applying for an adjustment of status, right now they only have to pay one fee. They don't have to pay anything additional to apply for a work authorization or a travel document. As of October 2nd, when the fee increases take place, they will have to pay additional fees, and it's like $550 for a work authorization and an additional $590 for the travel document. So what that means is the fees have almost doubled. So, you know, the advice to people out there that are considering filing these types of applications is probably to do it before October 2nd. Because once October 2nd hits, people are going to have to start paying these increased fees. So that, I think that probably covers everything on the fee increase. One of the questions may be, you know, is this something that they could file a federal lawsuit? It may be difficult because USCIS does have the ability to increase the fees. I think it just depends on whether those fees are considered to be reasonable. As I said, some of the fees have increased by, you know, 200 or 300%. So I think there's certainly an argument that they're not reasonable. The fee for like a H-1B is only increased by $100. So I think there's certain fees that probably are reasonable. And these fees actually, they take effect in October, but then they run through until 2027.
So if you already have a document filed, you've already submitted the application,
Yep.
It hasn't been approved, are you going to have to pay an increase or not?
No, so it's only applications that would be received after, you know, either on October 2nd or afterwards. So if you've paid, you know, the current fee, and if for example, that's what I was saying, if somebody wants to file for naturalization now, they would then be able to pay the existing fee, whereas after October 2nd, they would have to pay the new fee. So it won't affect any, you know, currently pending applications.
Okay. Well, can you tell us about the executive order issued on August 3rd, 2020, and the Trump administration's plan to increase H-1B enforcement?
Sure. So there's kind of two issues there. So the executive order that was signed on August 3rd basically requires that federal government agencies review their contracts to see whether any non-immigrant workers were employed and whether by employing them it had a detrimental effect on US workers. So for example, you may have an individual that is working through an IT staffing firm, but they're actually working for the Department of Labor. So the Trump administration, I think the intention is to stop those federal agencies from employing people that are on non-immigrant visas like H-1Bs and other types of work visas. Right now, all the executive order does is require the agencies to review their contracts and submit a report within 120 days. So that 120 days obviously takes us past the election. If Trump is re-elected, then I would expect to see further measures, essentially, preventing these federal government agencies from hiring H-1B workers. If Trump doesn't get elected, I don't think anything's going to come from that. The other important thing that the executive order does is it requires the Department of Homeland Security and the Department of Labor to make sure that employers have been complying with the H-1B program. So about 3 days, I think it was about 2 or 3 days before the executive order was signed, the Department of Homeland Security and the Department of Labor made an announcement that they plan to join forces and start sharing data. So what that means is that rather than the Department of Labor just conducting their own investigations, if an employer submits an application to USCIS and USCIS officer sees a potential violation, for example, if the H-1B employee hasn't been paid the proper wage, if there's been a period where they weren't paid because work wasn't available, the Department of Homeland Security, USCIS, will essentially refer that case to the Department of Labor, and then the Department of Labor will do their own investigations. What that means is that employers that have kind of run foul of the rules will potentially be subject to penalties. They may have to pay back pay. So, the two things combined, the executive order and then this recent announcement, seems to suggest that the Trump administration wants the various agencies to increase the H-1B enforcement. So the one thing I would say to employers is to obviously make sure that they are paying the proper wage. They are filing H-1B amendments when they're supposed to be, that they check their internal files. So for each H-1B petition that has to be filed, they have to prepare what's called a public access file, which contains certain information as to how they calculate the wage. I think we're likely to see a lot more audits from the Department of Labor on those things. So it's important that employers start reviewing those files now to pick up on any, potential violations. And it may even be worth kind of working with their immigration attorney and doing almost like an internal audit. So that way they can see, if there are potential violations, what things can be done to try and fix that. Because if the Department of Labor does an investigation and they pick up on it, then I think those penalties are, potentially going to be higher. Whereas I think there's maybe things that employers can do to try and reduce the effect of those penalties and paybacks. Sorry, I can't hear you now. I think you're...
Thank you so much.
Okay.
That's good to know about those changes and the importance of doing some due diligence and reviewing your files. Looking forward, what more changes can we expect to immigration? Is there anything on the horizon right now between now and the election? And then maybe looking past the election, what do we anticipate?
Sure. So, I mean, there's one piece of positive news which I would like to share first, because, I'm always giving people bad news about all these new restrictions. So it's always good to be able to kind of give something positive. So there was a H-1B lottery that was run this year. There was a registration period in March. And then the applications that were selected were, the employers were submitting petitions in April, May, and June. So the American Immigration Lawyers Association announced yesterday that USCIS may run a second lottery. In other words, they may pick some of the registrations that were previously submitted and allow people to submit petitions. And this morning, we actually have 3 additional cases selected. So what happened is, because of COVID, a lot of the applications that were selected never got filed because people lost jobs, people were laid off. So those numbers have essentially gone back into the lottery, and USCIS is now conducting a second filing period. So what I would say to employers is to check their My USCIS accounts to see whether some of the registrations have been selected. We had a couple of emails this morning kind of informing us that they had been selected. So I believe that the next filing period is actually going to be August 17th until the middle of November. So what that means is somebody that's in the US, they could be on OPT, STEM OPT, they applied for a H-1B this year, it didn't get selected, they may still have a chance of being selected. So, and I think they should find out this week, because the 17th is what, is it next? That would be Monday, correct? 15th, yeah, correct.
Yes,
yeah, so I think most of, if somebody is going to get selected, they will probably find out today, potentially next week as well. But it's, I would certainly say to employers to check their accounts today. But in terms of the question you asked, what can we expect going forward? Because we only have 3 months left until the election, I think we are probably going to see, potentially more proclamations, more executive orders. It's also possible that we may see a new regulation in relation to the H-1B program. So one of the things Trump has been talking about over the last few years is moving to a merit-based system. He's also talked about scrapping the H-1B lottery, awarding those visas to the highest paid salaries, which would be in itself problematic because, the likes of like Amazon, Facebook, and Google, they file, thousands of these applications a year. And obviously they're going to be paying much higher salaries than some of the, the smaller to medium-sized businesses. But that type of regulation would have to go through the formal rulemaking process. And because we only have 3 months till the election, that type of rule would really need to come out within the next 2 to 3 weeks, because it would have to get published in the Federal Register. There would have to be a comment period for about 60 days, and then they would have to publish the final rule and respond to those comments. So I think it's possible maybe in the next 2 to 3 weeks that we may see some new rules, particularly in relation to the H-1B program. Beyond the election, it really depends on who gets elected, because if Trump gets reelected, we could certainly expect to see the proclamations extended unless a federal judge rules that they're unlawful. We could certainly expect to see further kind of restrictive measures, whereas if Biden gets selected, I would expect him to kind of roll back some of the measures that Trump has put in place. Biden has also talked about potentially reducing some of the backlog for, EB2 and EB3 candidates. So it really depends on the election. If Biden gets elected, it's going to be a lot more favorable to immigrants. If Trump gets elected again, then we're probably going to see a lot of what we've seen in the last 4 years.
Okay, thank you. Well, what can employers and employees do to prepare themselves for further change?
I think the best piece of advice is probably just to try and stay up to date on any potential changes. So that means kind of checking the news, checking USCIS website. Certainly for F1 students, they need to be checking the SEVP announcements, because they provide a list of frequently asked questions on the ICE website, and they regularly get updated. It's also easy advice to give, because even as an immigration attorney, I've been finding it difficult to keep up to date on the immigration updates, because every day when I wake up, there's something new. So, I mean, that's probably the best piece of advice. I kind of mentioned, employers do need to start kind of reviewing their internal files, making sure that every petition they file, for example, a H-1B, that they do have a public access file, that the public access file contains the relevant documents. They need to make sure that they're paying the proper wage, essentially making sure that they're complying with the regulations, because we are potentially going to see a lot more enforcement. But, you know, other than staying up to date, maybe signing up to like an immigration newsletter, whether it's through our firm or, you know, through their own attorney, I think that's definitely a good idea.
Well, thank you for that. Well, we're going to see if there's any questions from the audience at this point. So if you would have a question for Chris, go ahead and type it into the chat box. And then I'll be reading your questions to Chris. And while y'all are typing, I'm going to go ahead and ask, what's one of the biggest mistakes that employers or immigrants make?
In any particular context, or just?
You can pick the context, but what kind of mistakes do you see and you think, oh, if only you had known this, we could have avoided this whole problem?
Sometimes they're not necessarily mistakes. Like in the H-1B context, you know, particularly we see it a lot more with IT staffing firms. If an individual is working at a project and that project comes to an end, sometimes there may be like a 2 or 3 week gap. Sometimes the employer doesn't pay that employee, and that's called benching. That's not permitted under the regulations. If somebody is put into a non-productive status, they still need to continue to pay them. So that's some of the, you know, when we submit these applications to USCIS, sometimes we see that, and USCIS will pick up on that. But to date, they haven't done anything about it. You know, sometimes they may deny an application, or they will approve it for consular processing, which means that instead of it being approved within the US, the person has to go outside of the US and go for visa stamping and then come back. Now, because of the new enforcement measures, USCIS is going to refer those types of cases to the Department of Labor. So, you know, that's one of the things that we see kind of frequently. The other thing that I see a lot is when they have an employee working at one location that moves to another location. In those circumstances, the employee is required to file a H-1B amendment to inform USCIS of the changes. That amendment should be filed prior to the person changing locations, and quite often that doesn't happen. But I think the problem for employers is that these projects come to an end all of a sudden, and then they're forced to move that person, and they don't really have time to do that. But you know, when they do have advance notice that the project is coming to an end and the person is going to move, let's say they're moving from New York to California, they need to make sure that they file that H-1B amendment ahead of time, because if they don't, and USCIS realize that the person started working at the new location, they could approve it for consular processing, which obviously right now is probably the worst thing that could happen, because nobody wants to be able to travel outside of the US and go for visa stamping. And the other thing is, you know, a lot of these consulates still remain closed. So if somebody is forced to leave, they're potentially going to be stuck outside of the US for many months.
Okay. Well, we have a question here from the audience. And this is mostly about how long it's taking to get documents back. So this individual's visa expires on August 31st, and you know they've applied for a renewal. They don't know how long it's going to take to get it. Do you have any idea how long the waiting period is?
Do you know, is this somebody that's in the US or outside of the US?
They're in the US right now.
Do you know what type of visa it is?
It's an H-1B cap exempt visa.
Okay. I mean, if it's filed in premium processing, you know, that requires an additional fee to be paid. Then it's a 15-day turnaround. If it's filed in regular processing, then, you know, it could be anywhere from 6 to 8 months. The problem is, if USCIS does furlough a lot of their staff at the end of the month, then it's impossible to say, you know, we are going to see a massive increase in processing times. We've even seen cases that have been filed in premium processing where USCIS is supposed to issue either a request for additional evidence or a decision within 15 days. And they've turned around to us and said, look, we can't get to this case in 15 days. We'll refund you the fee, but then the individual has to wait. But yeah, I mean, with these types of visa extensions, they're taking probably 6 to 8 months but those processing times are increasing. So, I mean, that's one of the things that I mentioned earlier, that's the type of case, if it wasn't filed in premium processing, I would recommend upgrading to premium processing, because it means they should be able to get a decision before USCIS potentially furlough, 2/3 of their staff.
This is a related question. It's a person who's on a wait period for a green card. Their application was approved in 2015, they say, but how long is the wait period now for that, for green cards?
So this is somebody in the US that's applied for a green card. Do we know what country they're from?
No, but I'm going to guess India.
Yes, so I mean, it depends on the type of green card, but I believe like EB2 and EB3 cases, they're still processing cases from 2009. That looks, obviously we're in 2020. I think it's 2009 or 2010, which, potentially looks like a 10-year wait, but those dates don't move forward in real time. So they could be, processing cases from July 2009, but 6 months later, they're only processing cases from August 2009. So it's very difficult to say how long the wait will be. One of the things I did hear this year was, this week, was that a lot of the unused family-based cases are actually going to move over to the employment-based. So typically, there's only 140,000 employment-based green cards available. Come October this year, there's going to be, I think, 250,000. So the numbers are going to increase. So what that means is that some of those dates are going to move forward, but I don't know how fast they're going to move forward. So, with somebody where it was approved in 2015, whilst it looks like 5 years, it could be a lot longer. But again, this is something that Biden wants to do. He wants to try and clear the backlog. So if Biden gets elected, we could see, more green cards being available, which would help clear that backlog. But it's certainly going to be at least a 5-year wait, and it could be significantly longer.
Thank you. Okay, here is another question. I'm not sure exactly what they mean, but hopefully you can sort through this. It says, is there a greater risk now with a citizenship application? I think is there a greater risk of being denied?
I wouldn't say so. And I actually applied to become a citizen this year, and mine was granted. But obviously, every case is different. And I mean, what I would say is, I don't think there's necessarily a greater risk of it being denied, but it does depend on the individual circumstances. So if somebody has, for example, a criminal history, that's something that would be taken into account, and they're certainly a lot harder on those cases. If somebody has like 2 or 3 DUIs, that's the type of case that would be denied. Whereas 3 or 4 years ago, I remember filing a case where the person had like 4 DUIs and the case was still approved. So they are a little bit harder on cases, particularly under the Trump administration. But if it's a straightforward naturalization case, then I certainly wouldn't expect it to have a greater risk of being denied. The one thing I would say is that the processing times have increased for naturalization cases significantly.
Okay. Here's another one. Due to the COVID pandemic, should employers expect that their job sites will be visited by DHS or DOL in result of the new enforcements?
I think so. I mean, that's, everything is pointing to kind of more enforcement, from a H-1B perspective. The June 22nd proclamation directed the various agencies to come up with regulations or measures to ensure that employers are complying with the H-1B program, particularly in relation to the LCA. I think a lot of the site visits have been put on hold because of COVID-19. But Trump is certainly pushing the agencies to start, revamping and start doing more investigations and audits. I don't know when they're likely to take place, because obviously the number of COVID cases is still on the rise. So I'm not sure that it would necessarily be safe for them to do that. But certainly going forward, I would expect more site visits. So, I mean, that's one of the things I mentioned in terms of making sure that the person is working where they're supposed to be. And that's why people need to file H-1B amendments, because if they don't file the H-1B amendment and, the agency goes to the last known work site and the person isn't there, that's going to be a problem.
Mm-hmm. Thank you. It's good advice. This is a question about a minor son who has or is getting a passport as his automatic citizenship. The person wants his citizenship certificate, and what is the procedure for that?
So, sorry, could you repeat that question?
Yes, so it's a minor child who is getting a citizenship passport as automatic citizenship.
So they were born in the US?
I'm assuming they were born here, and the person wants a citizenship certificate as well. Do they need anything beyond their passport?
Yeah, they don't necessarily need them. For example, my children were born in the US and I've got them US passports. You can apply for a certificate.
Okay.
There is a form on the USCIS website. Unfortunately, I can't remember what that form is, because it's rare that we submit that application, because most people just apply for the US passport. But whether that person wants to email you, you can pass on my details. I can certainly send them the link to the relevant form, but it is possible to apply for a certificate.
Okay. We will get that information out to you. Just email me at info@usicoc.org so I have your email address, and then we'll get that information back to you. All right, another question. What would be the impact of consular processing petitions? For example, if a consular petition gets approved, can we stay in the US until this pandemic situation gets controllable?
Yes, so I think it depends on the person's current status. So are there any more specifics about
That's
the case?
all that's there.
Yeah. So let's say there's somebody in the US that's on an F1 and they're on OPT or STEM OPT. They apply for a H-1B and it gets approved for consular processing. As long as they still have time left on their STEM OPT, they can remain in the US. So as long as they can maintain a status in the US, they can stay. There's certainly no requirement for them to go for H-1B stamping immediately, because it is a consular processing case. So if they do have time left, and they have a valid work authorization under their F1 status, I would say to stay in the US until, such time as the COVID-19 pandemic passes and obviously the consulates reopen. Because the problem now is a lot of the consulates remain closed, and obviously with the proclamations, it's very difficult for people to go for visa stamping. So if this person were to leave now, they would probably be stuck outside of the US, but they can't just remain in the US unless they have a valid status. So that's kind of key. But again, because that's very much a fact-specific scenario, if that person wants to email me, I'll be more than happy to advise them.
Okay, go ahead. And again, the person who asked this question, if you could email me at info@usicoc.org, I can pass that information along. We have a question here where there is an American citizen daughter.
Okay.
And then she has parents in India.
Okay.
Is there a way for her parents to get permanent residency in the US right now?
Okay.
Like if she wants to bring her parents over.
What was she can file for, so, do you know whether she's filed anything or not?
No.
Okay. Yeah, she can certainly still file the application with USCIS, so she could file an I-130 for both parents. That will still be adjudicated by USCIS, subject to obviously, the increase in processing times, the furloughs. Once that's approved, it will get sent to the NVC. And then once the NVC collect application fees and documents, it will then get sent to the consulate. Well, that obviously, because the consulates are closed, they're not likely to do anything. But also that wouldn't be one of the categories that comes under the proclamations. So it's not, I believe it's not. So they wouldn't be able to get a visa. But the reality is, even if this person filed an I-130 for their parents now, it's probably going to take 12 months for that application. to be approved, by which time hopefully the consulates will be reopened anyway. So they should be able to go for visa stamping once things reopen.
Okay.
Yeah.
All right, so our next question, I think it's talking about our conversation we had earlier about the executive order and the federal projects. The person is asking if you explain briefly about the federal project H-1B restrictions. If you could just talk a bit more about who that applies to. And I know we talked about it a bit earlier. But.
Yeah, so it doesn't really apply to anyone right now. All the Trump administration is doing is they're asking the federal government agencies to review their contracts to see whether they employ any non-immigrant workers and to see whether that has had any detrimental effect on US workers, and if so, to provide suggestions to kind of revamp their policies. So those government agencies have to provide a report within 120 days. So anyone that's working, as I think I gave the example of somebody that's working on a H-1B, they may be placed to work at, for example, the Department of Labor. They can still continue to work there for the foreseeable future until such time as we see further measures. And again, if Trump doesn't get reelected, I wouldn't expect anything to come of that. Because again, I don't know the exact numbers of people that are working for federal agencies. I imagine it's still within the thousands, but anyone that's working there right now is not affected because all the Trump administration is doing is asking those agencies to review contracts and nothing more.
Now, does that affect private business at all, or is that only government entities?
No, that particular executive order is just federal government agencies. So it would be, the Department of Labor and all, various other agencies. So it wouldn't affect private businesses. I mean, I guess it would affect private businesses if they, if it was an IT staffing firm that had put that person to work at the Department of Labor, but it doesn't take any effect now. It's only going to take an effect if they implement further measures.
Okay. Well,
but it certainly indicates that may happen.
Okay. Well, here's another question. Can an F1 student change their visa status? The question says to a talented special visa, maybe they're meaning H-1B. It says not sure what the name is, while they're in the US. So how would you change from a student visa to a talented worker visa?
Yeah, I mean, they could be talking, if somebody is on F1, in order to apply for a H-1B, they have to go through the H-1B lottery process, which was already run. The registration period was in March. So the only way they would be able to apply for a H-1B is to apply in next year's lottery, which again would probably be between March 1st and March 20th, unless they're working for an employer who would be exempt from the cap. So there's certain employers like universities or associations that are affiliated with universities where somebody could apply for a H-1B without having to go through the lottery process. The only other, the other talented visa, there's one for an O1, which is for people of extraordinary ability. But if somebody is on an F1, it would be a very difficult transition. So I think they're probably talking about the H-1B, but they would potentially have to wait until next year to do that.
The questioner has clarified it's not an H-1B, and they say it's a visa to do a business. Do you know what they're talking about?
There's investment visas. There's an E2, for example, but it wouldn't be applicable to somebody from India. So I think without knowing which, somebody can apply for a change of status within the US, provided they're maintaining their current status, but it would depend on the type of visa. So I think, again, that's probably very fact specific. So if unless that person can clarify, if it's an E2, it's certainly a possibility.
Okay. All right, another question. If a citizenship in 400 was filed in June, how long will it take to get an interview call?
I guess it depends on whether they've received a biometrics notice, because a lot of the application support centers have been closed, which means people haven't been able to go for fingerprinting. Once somebody goes for fingerprinting, the FBI then does a background search. and that's really what gets the ball rolling. So if they've already given fingerprints, then potentially, you know, it could be, you said it was in June?
Yes.
Yeah, I even looked at the naturalization processing times the other day. They had increased. I forget what they'd increased to. I think it was maybe like 18 months. You know, don't quote me on that, but I would certainly expect it to be another 12 to 18 months.
Yeah, I think the overarching theme here seems to be you're going to have to wait.
Yeah, it's the same, you know, with all types of visas. I was looking at EB5 visas, which is an investment visa. The processing times of that have now increased from 49 to 74 months. And, you know, we're talking about people that have invested $500,000 in the US economy, have created jobs, and they're now having to wait 5 to 6 years just to get an approval on their application. So it's pretty much across the board that we're seeing the increase in processing times. But if USCIS does furlough their staff, those processing times are just going to be on another level.
It's going to be interesting.
Yeah.
All right, are there any other questions from our audience? Just wait a couple minutes and see if there's any more questions.
Okay.
Do you have any concluding thoughts, though, Chris, about things that our members might like to know about the immigration process and what's been changing?
Yeah, I mean, there's definitely been, you know, the changes we've discussed today. I've only really gone back as far as April. Obviously, in the last 4 years, there's been a lot of different changes, a lot of stuff going on with the H-1B program. There's also other stuff that relates to, you know, asylum, DACA cases, which I didn't cover today. What I would say is, you know, if people need updates on things that I haven't covered today, they can always reach out to me. But the biggest thing is just staying up to date. As I said, I'm trying to stay up to date as much as possible. I provide an immigration newsletter once or twice a week, just because there's just so many updates out there. But yeah, that's going to be the biggest thing for people, is to look to see what happens over the next 3 months. If we do get a change in presidency, my hope is that things are going to become easier. If USCIS gets the funding, then they'll be able to continue. We may see processing times come back down, and I think it's going to be easier to file applications. The one thing I would say is, in the last few months, despite all these restrictions and measures, we've actually seen a huge increase in approvals for H-1B applications, to the point where we're really seeing 100% approval rate. So that's at least a positive. So, you know, people that are considering filing H-1Bs or other types of applications that are worried that maybe they won't get approved, we are still seeing a lot of approvals. So it is still worth filing those applications.
Very good. Well, we have one more question here. This is a clarification about our F1 student. The F1 student has a business in their home country. Are they allowed to receive money from their home country and work with that business while they're in the US? So work for a business that's abroad while they're here on an F1.
So whether they can work in the US but receive and essentially get, I think it would be allowed, and you know, that's maybe a question I need to consider further. As long as they're not being paid within the US and they're being paid outside of the US, it may be okay. I think it really depends on the type of business. I mean, if they're going out and doing things that would be considered employment within the US, it may be a problem. But if they're not employed by a US worker and they're only working for the company outside the US, it may be okay. And I really think it depends on the type of business, the type of work that they're doing. Because if they're doing, you know, if they're getting clients, for example, in the US, that could be considered employment, and that would probably be considered unauthorized employment. But that's maybe a little bit of a gray area and maybe a trickier question to ask.
Well, and that may be one that you'll need to consult with your attorney so you can fully explain your circumstances.
Yeah.
And again, this is not legal advice, and we don't know all the details of your situation. So make sure that you consult with your attorney to get legal advice on these situations. All right, let me see. We might have one more question. Let's see. This individual is on an EB2 visa, and they want to know what are the requirements for filing as an EB1.
Okay, so I mean, there's three. It depends on the EB1 category. So there's three categories. There's EB1A, which is for people of extraordinary ability, and that is reserved for the top 1 to 2%. It's the most difficult application to get approved. There's an EB1B, and an EB1C. I think the EB1B is for outstanding researchers and professors. And then the EB1C is for executives or managers that have worked abroad. So if this person, does it say whether
it looks like they're a professor. They teach chemistry at a university.
Okay, so that may be an EB1B, which is outstanding researchers and professors. There's a whole list of criteria which somebody would have to meet. That's probably not something I can go over. And to be honest, I don't recall the exact criteria, but any EB1 filing, whether it's an EB1A or an EB1B, is certainly a very difficult application to be approved. The EB1C is certainly the more straightforward one. But again, if that person wants to provide maybe some more details, I'd be more than happy to give them a consult on that.
All right, so this is going to be our last question. This individual is asking, are there any exemptions given for L1A managers? And they say, I know a few exemptions were announced for H1s.
Yeah, so the Department of State that made the announcement on Wednesday, they provided exemptions for H1B holders, for J, and there were also some for L, but it's more aimed at senior managers, people that have very extensive experience, something that's maybe more unique to the employer. So it's aimed at more senior people. So if somebody, for example, was coming to the US to set up a new office, they wouldn't be exempt. So there's, this person can always look at the Department of State guidelines that came out this Wednesday, but they would have to be somebody that has many years of experience abroad and can show that they offer something, perhaps is a little bit more unique. So there is some exemptions, but I think it's still going to be limited to, very few people.
Okay. Well, thank you so much, Chris, for your insights and information that was very useful for all of us. We're really glad that you hosted this webinar with us.
Yeah, and thank you for the invite. And, I appreciate being here today. And I appreciate I covered a lot of different issues. I wanted to try and cover as many issues just to at least make people aware of the issues. I think if people have more specific questions, there's certainly a lot of information out there. But yeah, I appreciate the opportunity. Thank you.
Thank you so much. Chris, also thank you to our audience for coming and for your interesting questions that we got to cover. If you have further questions or you want to get connected with Chris, please email me at info@usicoc.org and I will get you guys connected and he can help you out as in an official capacity as your attorney. Don't miss out on our webinar next week. We've got our tax planning and lending for small businesses at 10 on Friday, the 21st. And you can register for that on our website, www.usicoc.org. Click to get signed up for our newsletters and the registration link is in there. Thank you so much. And please reach out if you have any questions. Everyone have a nice day.
Thank you. Bye.